to clarify different types of disturbance or disruption to service and whether a graduated fine could be put in place. Mr. Johnson of the OUR suggested a review of Section 28 as the word any, in quotation, makes the provision wide. He also suggested that it would be useful to have some categorization in terms of the specific lines being referred to in the section to ensure that the word any, did not include something on a private system. The ministry requested time to review this matter. We also looked at Section 55 dealing with regulations and the OUR's proposal for a rulemaking power to be carved out to facilitate their functions under the Act, using language similar to that used in the Telecommunications Act. Ms. Campbell at the ministry said she would consult the team on the matter. In relation to Section 55, subsection 1, paragraph I, the ministry recommended the removal of this provision since contemplation was being given to the removal of Section 45 in its entirety. This recommendation was deferred pending the outcome of the deliberations on Section 45. We also discussed the provisions under Section 62, the Savings and Transitional Clause. The ministry indicated it would revisit Section 62 after Ms. Eaton's intervention, that the ministry's proposal to delete subsection 2 had to be considered in tandem with subsection 3, and that subsection 3 could be amended through the drafting once the policy position of the ministry was clearly stated. We haven't gone through the minutes of September 13, 2023, but Minister's brief does note that there were also matters deferred from the meeting of September 13, 2023, which should be addressed at today's meeting. The ministry should provide a response to the JPS suggestion that in Section 47, subsection 6, the definition of a significant power outage should be in line with the definition of a major system failure. The ministry expressed the desire to discuss the matter with the OUR before providing a response. The ministry should revisit and add further clarity to the provisions relating to rural electrification, specifically addressing the circumstances in which the main service provider could not or did not wish to provide electricity for certain rural areas, and another entity or individual opted to provide the service. For example, what would constitute encroachment? The ministry was to consider the possibility of providing incentives for those entities that opt to provide that service. So, and with that, we had also confirmed another meeting date of October 26, 2023 at 2 p.m. We will discuss, I'm sure we'll mention that again at the end. So with those remarks, which essentially highlight the matters arising from the minutes of the last meeting, I am going to now turn over. Is Ms. Campbell here?
I'm here, Chair.
Hi, Ms. Campbell, how are you? I'm going to turn over to you and I ask you to just take it from the top of your list of things to do coming from those two meetings, notwithstanding we haven't looked at September 13 minutes yet. Thank you. Go ahead, Ms. Campbell.
So in relation to Section 28, the offences, we went back and we considered the concern expressed by the representative, the OUR, and the recommendation from the committee that the offences, that there is a tiered offences instituted. We scanned different jurisdictions in the Caribbean. And based on what we have reviewed, we noted in Barbados, in Trinidad, and Belize that there is a provision that is similar to the wording of Section 28. And we also noted that they had one offense for that provision. Importantly, we noted that they defined electric line, and those legislation had similar language. And electric line is defined to mean a wire or in, I'm sorry, I'm not sharing. Are you seeing my screen? And Section 28 being shown.
Yes, seeing it now. Thank you.
So in relation to Section 28, we noted that in the legislation I mentioned that electric line was defined to mean a wire or wires, conductor, or other means used for the purpose of conveying, transmitting, or distributing electricity with any casing, coating, covering, tube, hole, or insulator enclosing, surrounding or supporting the same or any part thereof or any apparatus connected therewith for the purpose of conveying, transmitting, or distributing electricity. So in that instance, the definition of electric line gives some specificity in our interpretation as to what lines may be affected. We note also with interest that the predecessor legislation to the Electricity Act, which is the Electric Lighting Act, from which a portion of the Section 28 provision, which we now have, was taken. It says any person who unlawfully or maliciously cuts or injures any electric line or work with the intent to cut off any supply of electricity shall be guilty of a felony. And the definition of electric line, which I read earlier from the other legislation, was also included in the Electric Lighting Act, which governed Jamaica prior to the 2015 Electricity Act. In that respect, the definition of electric line was not transferred into this act. We considered then that perhaps the provision could remain and we add electric line to give specificity to the lines which may be affected. And we know that those are the transmission and distribution lines. And so that is our first recommendation to the committee, is whether we could keep the fine based on the information from the research, and we propose to add the definition of electric line so that there is, in our estimation, a narrowing of the ambiguity. In the alternative, we propose that we separate the fines for transmission lines and distribution lines, because they are the critical lines under consideration for this provision. And we include separate fines where the offender is a body corporate and where the offender is an individual. And we propose for body corporates that the fine be up to 7 million for the transmission line, based on advice that the transmission line, any incident which affects or cuts off the supply from the transmission line would be more far-reaching as opposed to the distribution line. So in that respect, we propose for a body corporate, if there is such an instance, then a fine up to 7 million be considered, and imprisonment not exceeding 3 years, or both fine and imprisonment, if the court so determine. In the case of an individual, the recommendation is for
I'm sorry, Ms. Campbell, can I ask you just to repeat that? So the fine for body corporate would amount to what?
7 million.
7 million.
Imprisonment for a term not exceeding 3 years.
Okay.
Or both.
And for
imprisonment.
Right. And for an individual?
Fine up to 3 million or a term of up to 1 year imprisonment or both.
Okay. And is it proposed that that is going to be the penalty specified at the amendment to section 28?
Yes.
Or is that going to be a general improvement on the general penalty provision at 53?
Yes. So it's going to be an improvement on the general penalty at 53 in relation to section 20.
Well, it will be in relation to whichever provisions don't have a specified penalty.
We were proposing, Madam Chair, that the different offenses have their own penalty, because from our initial review, we realized that they were not properly weighted throughout.
Okay, so you're proposing to this committee then that we will remove section 53, which is a general penalty provision.
Yes.
And that every offense set out in the act will have its specified penalty included in the provision. Okay. Okay, the members have the clarity of the proposal that Ms. Campbell is making in relation to section 28. Are there any questions or comments? I'm so sorry. Ms. Campbell, were you finished? I did interrupt you. I beg your pardon.
So I'm to mention, to conclude, in relation to distribution lines, that the fine to be considered by this committee in relation to a body corporate, a fine up to 5 million or imprisonment not exceeding 2 years, or to both fine and imprisonment. And if the offender is an individual, a fine of up to 2 million for a term of up to 1 year imprisonment or both.
So for distribution lines, the fine is 5 million for a company, 2 million for a person.
Yes.
But for transmission lines, it's 7 million and 3 million.
Right.
So, Chairman, what we're saying is that there won't be a graduated fine. This is body corporate and individual, 7 and 3, 3 and 1, meaning 3 years, 1 year, and 7 and 3 million. So we were proposing that the ministry reviews to see whether or not there could be a contemplation for something graduated. Is this is what we're referring to, correct? Or not? Am I
Miss Campbell?
Campbell?
Ms. Cavill, can you put back up the definition of electric lines for me, please? That you're proposing to insert?
Are you hearing me now?
Yes, we're hearing you now.
Okay, sure. So that is our proposal, Senator Allen.
Okay.
Does that
And this is
satisfy?
based on the review that you have done and regionally to see whether this existed elsewhere.
That's correct.
I'm sorry, do we have this document that you have on screen?
No.
It's very difficult to follow it when it's on screen, and I'd like to be able to flip and look at it. Pardon?
I'll have it distributed. Share.
Yeah. Do that for me in the future now, because it's helpful for us to be able to, it's hard to look at it on the Zoom box. Okay, so members, can you scroll down a bit to the top of just above where you have the definition of electric line, where you start with option 1?
Yeah.
Right. So original, but okay, and then go down past the definition now to option 2.
I'm sorry, option 2 is beyond the research.
Okay.
This is option 2.
Okay, so I'm trying to sum up. So option 1 is that you would insert a definition of electric line, and you would still adjust the penalties, yes?
Yes.
Okay, and option 2 is you wouldn't insert a definition, but you would create a penalty for transmission lines as distinguished from distribution lines.
Correct.
Okay. Members, comments? I think I'm in favor more of inserting a definition of an electric line and leaving it then for the circumstances of trial to determine whether the higher end of the fine is warranted because it's a more serious line versus the lower end.
So would that incorporate, Chairman, the concern, I believe, that was raised that some lines go to certain places and are probably more critical to essential services, and or is was that the one, the distribution versus supply? Or no, that's not what I'm saying.
Distribution versus transmission lines, distinguishing the penalty between those two does not, in my view, take into account who the victim is.
Okay.
It only takes into account what the importance
disturbed
of the particular line. Yes.
Mm.
So
we're saying that the first option gives you a better chance to protect it or defend the victim then, and the victim could be a hospital, for example.
That is my view. I'm open to hearing from members. I don't know if Mrs. Mesado at the chambers would like to weigh in. I think I see her. Carissa, are you here? Forgive me for cold calling you, but do you have a view on this or any guidance to offer us? Not hearing you. I think you're muted. Not hearing and not seeing her, no. Okay, while she's obviously something is going on. While she's trying. Yes.
Hello. Yes. Hi. This is Ashley Murray. I'm from the chambers. Miss Masado is having a bit of a difficulty. So she asked me to relay what she was saying.
Okay. Thank you. Go ahead, Ms. All.
Yes, in relation to the fine, we noticed that there is a body corporate fine up to 7 million, but we're not aware of there being a fine for up to 7 million in the parish court. So we're just asking if LRD or if anyone else could double check on that for us. As far as we know, the parish court fine goes up to 5 million.
I think you might be correct, you know. Is it who is here from LRD? Do I see Mr. Hang on, losing my screens.
Good afternoon, Chair.
Yes, who is speaking now? Forgive me, I am moving between all the different windows with all the different matrix and minutes and so on. Is that Mrs. Mesada now? Who just spoke?
It was Miss Keisha West.
Oh, okay. But now I'm not seeing her on the platform now. Okay, I'm seeing her now. Okay, she's saying they're going to check and advise. Okay. Members, can I ask for your comments on that? So even accept this matter of the amount of the fine, the two options Ms. Campbell has presented. And I'll just summarize again. The first one is that the fine is increased and the definition is added of electric line. And in the second option, no definition is added, but fines are increased and distinguished. Separate fines are separate penalties are provided for in respect of distribution lines as against transmission lines.
Chair, if I may, I'm inclined to go with the one with the definition embedded in it. But I do want to hear from the chambers in terms of the options, because I don't know that either one is wrong. It's really which one we think would be the more effective one, but just from seeing this here now, because I don't have this document, I would say the one with the definition embedded in it.
Okay, thank you for that, Senator Morris. And I will say too that the concerns, if I recall, and Senator Allen articulated it earlier, the discussion at the time really centered around the question of the end user being seriously impacted by someone who would commit such an offense. So cutting the lines to a hospital, infirmary, you know, places of that nature could very, very seriously impact public safety and public health. And I'm not entirely sure that the options you have presented us with, Ms. Campbell, put in the minds of the court, although I guess certainly this would be some sort of aggravating factor at sentencing. But I just wonder, and I don't know if any of the technical team can assist us. Our intent is to ensure that where this offense is committed and impacts those essential services and has a, you know, potential risk harm to public safety and public health, that can be treated with some much more seriousness than you know, someone who would cut lines to, you know, I don't know, that only affect one lamppost for argument's sake. Have these proposals contemplated that? I don't know if the chambers could opine.
Testing.
Well, we're hearing testing. Mrs. Masada, go ahead.
Okay, thank you. Testing my audio before I started. So I'm not sure what happened. What happened in the chat is that I don't have any objection to part approach. Of
Okay, you're coming in and out for us. You're not so clear. 1 minute you're clear, and the next minute you go quite low.
Okay.
Try again.
I was just considering the approach suggested by Ms. Campbell. I was just meant that I think it's more of a policy on a particular preference. One of the
No, we're losing you. We're losing you. So I got from you that you think it's more of a policy decision that has to be made.
Preference as to which one, but depends on the technical situation and what I would like to hear
Do
from
you
the
want to
ministry.
try removing the headphones? Is that any better? No, we don't hear you at all without the headphones.
I made my chat.
Thank you. I'm not sure if I agree, though, in terms of the policy decision between the two. Well, the decision between the two options may very well be a policy position. But the question I am asking is, do any of those two provisions address the concern that the committee had in its earlier discussions with this offense? Because as Senator Allen had articulated, and Senator Allen, tell me if I am reviewing your comments incorrectly, the concern you had was the person who would unlawfully and maliciously cut or damage electric lines with the intent to cut off supply in reference to a critical entity, organization, or service like a hospital, police station, for argument's sake, that kind of thing, emergency fire station, that kind of thing. So is that correct, Senator Allen? Have I captured your concern?
Yes, you have.
Okay. So my question to the technical team is and to the ministry is, how do these provisions affect the intent that Senator Allen expressed in her concerns?
The ministry have a recommendation of presented.
Seem to be having technical difficulties today, Chairman. Not
yes,
here. I
it seems
hear that
so.
question a while ago, and I think that might have been Minister Morris Dixon.
No, I think it was, was it Mrs. Mesado?
No, I was asking the ministry had a recommendation in terms of the approach that were laid out to kind of hear that response.
Mm-hmm. Is there anybody here from Parliamentary Council who may be able to opine? Folks, hello.
Hello, good afternoon.
Whose voice am I hearing now?
This is Samantha Eaton, Office of the
Oh, hi,
Parliamentary
Miss Eaton.
Council.
There you go. Yes, you just, okay.
Okay.
Yes. We're seeing you now. Thank you.
Okay, right.
Did you hear my concern? Am I clear, or do you need some clarification?
My understanding of the discussion is that where the criminal act results in injury or has an impact on a particular class of persons, that in the interest of public safety, that the penalty should reflect the vulnerability then, or the person who is affected by the offense. Now, it really is a policy issue. From a drafting perspective, this idea that your penalties may be more severe because of the particular types of circumstances is not unknown in legislation. So in other words, for example, as you had said, if the loss of power is experienced by a hospital or an infirmary, that can be constructed as an element of the offense and an appropriate penalty attaches. But that is really an issue of policy.
So do these two proposals allow for that or no?
My understanding of the recommendation as it is presented, the ministry's matrix, is that it's referring to penalize, making it, the penalties are informed by whether or not the perpetrator is a body corporate or an individual. Presumably in the case of a body corporate, there is a larger fine because of course the body corporate's interest perhaps would be that of profit margin. There might be a financial context, and so it is more appropriate to have an increased fine in respect of the commission of the offense by the body corporate. But as to whether or not both penalties, if I'm understanding it, the categories of penalties then are attaching to the type of infrastructure that is damaged, which is whether it's a distribution or transmission line, but not to the effect of that loss of transmission. Right. So in other words, it would not take into account, the severing the distribution line may mean that a residential area is without power. But what if severing the distribution line, which I think is the concern of the members of the committee, cuts power to a hospital that doesn't have sufficient generating capacity, and you have loss of life of patients in the hospital? That now is a different, is a level of severity that you would want to see the penalties or the criminal offenses addressing. This is my understanding.
Yes. Yes. And these two proposals don't reflect those concerns that were expressed, I don't think. And I think that's what Ms. Eaton is agreeing with me on.
Right,
Ms. Eaton?
right.
Well, this is my understanding, yes, because the reference here is to the infrastructure. But as I said, ultimately, the offenses, the element of the offenses have to do with the matters that the mischief then that you're seeking to address or to deter people from engaging in certain types of conduct. And certainly when there's a particular type of loss that could be built in as an aggravating kind of feature that would then inform the penalties. And there are various drafting techniques, but ultimately it's what is decided, what is, what we're instructed to prepare at OPC.
Okay. Okay. Ms. Campbell? Is Ms. Campbell on the platform still?
Yes, Chair, I'm here. Okay.
So Ms. Campbell, you've heard the discussion. I'm looking at the time, it's 2:59 and we've moved through one point. So I want to speed up a little bit. What is the position of the ministry in relation to this issue? You heard the concerns of the committee. We don't think that those concerns are captured by the proposals you have here, although we acknowledge that there's been an increase in penalty and the definition of electric line proposal, I think, is attractive to some members. But how does the ministry respond from a policy perspective in respect of the potential impact of an offense like this and the concerns of the committee's members hitherto expressed?
I mean, it's certainly something we can look again at, but when we were discussing internally, we considered in terms of the movement of the fines that and we did acknowledge that, you know, a part of a distribution or transmission line could be cut, but then the extent of any effect, you know, may differ depending on who is affected. We considered that the fines were recommended on the basis of the extent of the coverage of a distribution line, the significance of it versus a transmission line, and that the penalties suggested the court may apply at the higher end or lower end, depending on the circumstances presenting.
Okay. Okay. So I understand it to be saying that where you have landed with the is it the maximum penalty that we're proposing?
Yes.
Right. So where you have landed at the maximum, you think would be an appropriate penalty to deal with the concern that the members have expressed, and the court would be free along that range to go to the maximum in such a circumstance if it's so warranted it.
That
okay.
Great.
Okay. I'm comfortable with that. I'm comfortable with that because what you're saying is that you, from a policy perspective, this is an appropriate penalty for that. And then, of course, if something like that were to happen to members, there would be other charges that would flow from that, certainly, if there was injury and death that resulted. Senator Allen, I do see and note your remarks. I'm grateful. Thank you. Do you have any comment before you go, Senator Allen, on this issue? Because we're going to leave it.
No, I'm not. I mean, no,
okay.
I don't. I'm fine. Thank you.
Okay, members, just given Ms. Campbell's remarks, can we therefore make a decision in relation to option 1 and option 2? My vote would be for option 1. I believe Senator Morris indicated as much.
Yeah, I am
Senator
still
Morris?
there. No, I'm still at option 1, and I agree with the team from the ministry that it gives flexibility embedded in there that will take account of the severity of the disruption and can, you know, we can have charges or the fine be in relation to the severity of the impact. And so for me, I'm still at option 1, and I think we do have some flexibility built in to differentiate between the impact of the disruption.
Okay, thank you so much. Are there any other members who wish to opine? Member Jackson?
I'm more inclined for option 1 also.
Okay. Any other members? I believe Senator Allen too was inclined for 1. Okay, so with that, then I think we can say, Ms. Campbell, that the committee is supporting option 1. Yes? And with that, we can move to the next matter arising.
So the next one is in relation to the provision for the system operator. We would want to defer that because we have not yet. The basis of my comment then was not to make a firm position because the matter of the system operator was not yet finalized by the committee.
What section was that?
Section 45.
Members, I don't know if you saw the note, but Ms. Beckford did indicate that this matrix that Ms. Campbell is looking at on the penalties had been sent to your email. So you can follow along a little bit better. So section 45, Ms. Campbell, you want to defer.
Yes.
What document are we looking at now?
That's not on the penalty matrix though. This was
yes,
in
I'm realizing
section 55, and section 55 has the rulemaking power of the minister.
I'm trying hard to follow you, Ms. Campbell.
Okay. So on that matter arising, we were looking at section 55 in the last meeting. And one of the regulation making power of the minister is to make regulation for in relation to dispatch activities and functions of the system operator. So my recommendation, even though we highlighted it on our presentation to the committee, that we may consider its removal based on the position taken by the committee on section 45. So section 45 has the function of the system operator. And we have recommended to the committee that the section be amended to remove the provision for the independence of the system operator as a ring-fence department within the single buyer. And the basis on which we had made that recommendation was the fact that that particular portion of section 45 had not been implemented in the act. And based on the circumstances now, the system operator operates from within the JPS. And we had also heard from OUR, where the committee had asked them whether or not they would take on those functions, and they had indicated to the committee that they could not, based on it would be a conflict with their regulatory role under the act. So may that remain deferred.
Okay. Any objections, any comments, committee members? Okay, very well. So we defer that one, Ms. Campbell. Let's go to the next one.
Sure. In relation to section 62, the savings and transitional provision, based on the intervention of Samantha Eden, we have not had any, we cannot point to any circumstance where this was utilized. This subsection 2, which had given a date, a time period for the rectification of matters in other licenses within a certain time, 3 months after the appointed date of the act. And also given that the time had passed and the fact that we interpret subsection 3 to still allow for subsection 3 actually authorizes any activity which is okay. So our interpretation is that subsection 3 authorizes the terms and conditions of any license which would be inconsistent with any provision any of the repeal enactments. We are of the view that because it appears to us that subsection 3 would still maintain those terms and conditions as valid, then subsection 2 could be dispensed with. I'm not sure if OUR has had any rectification matters brought to them, because based on subsection 2, those matters were to be submitted to the OUR.
Good afternoon, Chair. I'm responding to the reference by Ms. Campbell. The OUR has not had any such applications, but I concur with her in relation to what the subsection is saying, is that what the Act does is preserve the rights and terms and conditions of a license or any document thereunder, given the passage of the Act. And so it saves it to be effective, and it does not require a rectification. So one would just simply have to wait until the expiration of those documents, and then they would fall away. And this is usually a provision because the obligations and rights and that have accrued under a pre-existing document before the law passes is usually preserved, because it is only if it is specified in an act is not applicable retrospectively. It is applicable going forward. And it is on that basic legal principle why those rights and obligations are preserved.
Okay, thank you. So in that case, the proposal, Ms. Campbell, is to delete subsection 2.
Yes, Chair, it remains so.
And you'll have an amendment to subsection 3.
No, Chair, we did not consider an amendment.
Oh, okay.
But I would want to know if
subsection 3 would read as is.
We'll take guidance, Chair.
Okay.
From Ms. Eaton, or, well, she intervened the last time.
Okay, members, so the proposal is that subsection 2 be deleted, subsection 3, I would assume, would become subsection 2, subject to any tidying up drafting that the drafters think fit. Are members in agreement?
Yes.
I have no objection.
Member Jackson?
No objection.
That's a unanimous endorsement of that proposal. Ms. Campbell, let's move to the next.
Sure. In relation to the definition of significant power outage versus a major system failure, we're asking for a little more time on this, as that we did consult with the OUR, but that one fell from our radar. So we'll have that ready for the next meeting. And well, electrification, we have further considerations given the movement of the portfolio just coming back to us. So we need a little more time just to complete what we're working on for that.
Very well.
And if we may now move to the general comments, recommendations. Okay.
Yes, please.
We begin at item 1, the recommendation from the OUR. It is being proposed that a review of the provisions in the Electricity Act that define or impact market structure is needed to ensure that it is reflective of or facilitates the desired medium to long-term evolution of the structure of the sector. This may include, for example, replacing references to the single buyer with references to supply licensee, and in other sections, inserting generic references to supply, dispatch, distribution, transmission, and generation licensee. Now, having considered this recommendation, and members would be familiar with similar recommendations that were made in respect of other provisions in the Act, there is no challenge to making adjustments to, for example, in replacing references. However, where it is going to impact the current market structure, we will defer to the policy in that respect. The reason is that the policy position was stating that the current market arrangements remain pending a comprehensive review of the electricity market. And based on that review, it will guide the decision as to what possible changes to the structure would be ideal. And in that respect, we would recommend that if it is going to affect the market structure, then that would be against the policy. But if there is any, if the amendment does not disturb the market structure, then we do not have an objection.
Thank you, Ms. Campbell. This is a peculiar general comment. Because it means what? That for all of the provisions that we have looked at, you're prepared to accept the OER proposal on them if they don't disturb the market arrangements.
Yes, or leads to inconsistency in any of the provisions.
I think we have to, well, I'll leave it for the committee members. I know my team and my colleagues are telling me my camera needs to be repositioned. I apologize. My computer camera has gone, and I've put a webcam in place to be able to take the meeting, and it's not cooperating with me so well. Is that better, Ms. Beckford?
Better, yes.
Okay, thank you. Yes, so in relation to this comment from the OUR, I appreciate the sentiment. I think I am clear on what the ministry's position is on it and the reason it's taking that view. I just think it's something we have to be minded, you know, we have to bear in mind. But I mean, unless Ms. Campbell, we are going to be looking through every provision that we have already accepted proposals to with this in mind. Has the ministry looked at that? I don't know if we had this specific lens when we gave our indication in relation to all the various other provisions we have settled on.
The ministry was asked by the committee chair to pull the various provisions where the single buyer term appeared, and we did give our comments on what we thought the removal the effect might be. So we've done that previously. We've done a separate matrix.
Right, okay. Committee members?
Unless I'm mistaken, Chair, when we so this is the could you scroll up or allow me to see a little bit further down, Miss Campbell, on this document?
Sure.
All right.
Not seeing it.
You're not?
No, unless it didn't change on my screen. I'm not sure what's happening.
But this is a different matrix from what was presented. With the
Yes, Miss Campbell, can I tell you, I'm really thoroughly confused because I made the comments I made a while ago in relation to the matrix that was sent on the general comments and recommendations, which is really what I thought you were referring to when you talked about the current market conditions and so on, and the amendments being made in consideration of that. I'm now looking at the screen and seeing that you have up avoided costs and PSOG. Where are we?
Sorry, I'm sorry, I thought we were sharing. I did select share. Are you seeing general comments and
yes,
okay,
okay.
in this now.
I'm so sorry. I'm so sorry. So this is where we're starting.
Okay, so could you just one more time, if you don't mind, Chairman, just so that I'm clear what is being proposed based on the comments all along. If Miss Campbell could just summarize this here, this is now the analysis and the recommendations based on the discussions that we've been having along throughout this process.
Mm-hmm.
Right? Okay.
So this is the OUR had in several clauses in the act, they have requested that single buyer be replaced with, I think, supply licensee or distribution licensee, depending on the actual provision. And we have the ministry. Okay, so let me not confuse. The reason I made reference to this particular comment from OUR is to bring to the recall of the members the different recommendations for specific provisions in the other matrix, which had the clause by clause comments and recommendations. This is not dissimilar to what the OUR had recommended there. It's just, this is a general comment. And I made mention of the fact that the committee had asked the ministry to pull from the legislation all the references to single buyer. We had given our comment on whether or not we thought it was appropriate for the reference to be amended to say with a supply licensee or generation licensee, whatever you are then proposed. And so in that context also, I am not certain if the committee had given a comment on, so if the committee had given a comment on what we had suggested, but what we had recommended in relation to the recommendations for the different clauses. But in relation to this matter, generally, the ministry has no objection. I hope I'm not confusing you, but if I am, please indicate. If it is, they have mentioned the amendment where to affect the market structure in the medium to long term. In relation to the policy, we're not there yet. We know that the 2016 license will come to an end soon, and we're also aware that there is need to review the electricity market as it is here.
Miss Campbell, can I interrupt you, please? Let me cut to the chase. The OUR wants us to consider future market structure conditions and therefore make amendments with that in mind. And they've given us the example replacing single buyer with supply licensee. Ministry is saying that they have no resistance to that except where it's significant, where it's significant, it changes the current market arrangements, because of course there are licenses in place that still have some time before they expire. So they wouldn't wish to make an amendment now that's going to impact those current arrangements. Am I summing it up, Ms. Campbell?
Yes.
Okay, so that is the position.
But Chairman, throughout the process when we were doing the review, at no point I don't recall us having any example of anything, any change, any proposed change that would have had any significant impact on any current arrangement, unless I might have missed that. Because we didn't, the concern was that we did not want after 2016 to have to make any major an overhaul to the act, based on the fact that by then we would have wanted a more progressive definition and not stick with single buyer, but instead supply licensee. So I don't recall there being anything that would have caused us to have concerns. And if there are, then fine. I don't have a problem proceeding this way. But if there isn't, then I don't see why we can't proceed with making the amendments.
I don't think, just would say to committee members that I don't know that we should be terribly delayed by this particular recommendation, only because it's a general recommendation. I think it speaks to the approach to be taken in looking at the review of electricity legislation and legislation impacting the electricity sector. But I think we have done that. I think Ms. Campbell is saying that the ministry has been tasked to go back and take a look at the various provisions, and that there is a matrix in relation to that, Ms. Campbell?
That is so true.
Was that matrix shared with us? I'm not recalling.
Yes, Chair. Was shared.
Okay. Right, and we had gone through that, yeah?
Yes, we did the presentation to the committee. Yes.
Okay. All right, so members can take a look at that. So I think we could move on from this. I think we're saying we're in agreement, and to the extent that we can do that, we have done that.
BMR Energy is recommending that the Act address the overall transparency in the electricity sector to allow existing participants to be aware of issues affecting the market, and to allow current and potential new participants the ability to fully understand the trends and decisions affecting the future. There is some ambiguity as to what matters should be made transparent, and we are of the view that in relation to, I suppose, data, market trends, and decisions affecting the future, those might not be within the the custody and control of the ministry. We do consider and that the current Electricity Act recognizes and creates a platform for stakeholders to consult with the minister in relation to system planning, and the IRP and other decisions coming from that process informs how the electricity sector will operate over a 2-year period, and stakeholders in the sector are invited through their representative organizations to be part of that process. So unless that process is not suitable, and then we are not aware of how to specifically address this matter of the transparency that they are requesting.
Sorry, I was muted. Members, any comments on this?
I'll just say that I agree with the recommendation that's there.
In terms of addressing it,
Yeah.
addressing it in the act?
No, where they had said that it's not necessary for it to be there, but however, there is the need for consultations. I think that does address the recommendation that was in the second column, I think it is.
Thank you, Senator Morris. Any others? I too agree that this is not a matter that ought to be enshrined in statute. It's really more of a protocol that should be followed as an industry practice. Okay. So we're accepting the ministry's position on this, yes?
Yes.
Okay, thank you. Moving on, Ms. Campbell.
Certainly. This comment from the Jamaica Institute of Engineers relates to the regulations under the Electricity Act, and we are working to deal with it there in terms of training and vocational studies for electricians.
Okay, so outside of the remit of this committee.
That's correct.
Very well. Number 4, the PSOJ.
The PSOJ is suggesting that the Act should be amended to include items stated below. Power purchase agreements with fixed cost. So the power purchase agreement is the agreement entered into between the independent power producer and the JPSCO in this instance. The OUR approved the terms once the parties have agreed, approved the terms of the contract. So they are recommending that no new generation capacity shall be procured that has a take or pay cost component as part of its power purchase agreement that could result in the single buyer and the consumers being forced to pay for electrical energy when such licensee does not generate such energy. They have exceptions as follows: where the project owner is prepared to accept a clause to give the office, which is the OUR, the right to revoke said cost component in the future and replace it with energy-only cost component. If the power purchase agreement or standard offer contract has a tenure of 5 years or less, 3, the take or pay cost component, if converted to energy only cost component, remains below the avoided cost of electricity. 4, where the system's operator can provide compelling technical reasons that a particular technology with such take or pay component is necessary, and the office agrees and then makes such recommendation to the minister. Because of the placement of the OUR in relation to this matter, we have consulted them to provide a comment on this particular issue, read the power purchase agreement with fixed cost. And I will present as they have provided. There is no PPA, which is a power purchase agreement, currently in the market or being considered for inclusion of such a clause. An express prohibition is therefore unnecessary in the legislation. Most PPAs contemplate purchase of energy supplied on dispatch, that is, dependable or firm capacity supplies, or when it is available to the grid, intermittent renewable energy sources as available PPAs. Dependable or firm capacity plants also have a capacity charge payable by JPS under the PPA at a rate of dollars per capacity per month. These charges cover the plant's fixed costs and are payable whether or not energy is purchased from the plant. This is not a take or pay scheme, as the payment is not related to the supply of energy. It should be noted that these plants are also subject to penalties where the energy required is not available whenever called upon by the grid operator. So that's the response in relation to the request for purchase agreements to have fixed costs.
Members? You've heard the ministry's recommendation on this. Any objections? As Minister Vaz likes to say, silence is consent. Going, gone. Thank you, Ms. Campbell. Moving on.
The other component of the PBCJ recommendation is in relation to the right to renegotiate power purchase agreements. The office, under the directive of the minister, shall have the right to renegotiate power purchase agreements if it is determined that less expensive energy technology is available that could significantly drive down the cost of electricity to consumers. The renegotiation should be conditioned on the following. 1, the process should be fair and transparent to all parties. And 2, the licensee or holder of the PPA shall agree to the new terms and price. Again, the OUR assisted us in providing a response. And the response is the renegotiation of a PPA is a purview of the parties to the agreement and subject to the approval of the OUR. Provisions addressing the manner in which PPAs can be amended should be and are included as provisions of the contract itself and should not be a statutory provision. The revision of commercial terms on the directive of a government minister and not purely on the basis of prices of new technologies available in the market without more may cause uncertainty in the market and increase market risk for investors.
Okay, thank you. Members, can I get any comments on this? I agree. The position
Yeah.
that is being taken.
And I do too, Chair. I mean, I think it's pretty reasonable in terms of what was written in the analysis and recommendations column. I think it makes sense there that that there is no need to include those recommendations into the act as we're considering now.
A very peculiar recommendation.
Very much so. I kept reading it over.
This is a PSOJ recommendation.
It is.
I wonder which member of the private sector would want to have a statutory provision that mandated them to agree to terms that they don't know about. A most peculiar recommendation. The committee is agreeing with the ministry on this, Ms. Campbell. Let's go.
So the next recommendation by WRB Energy. It is being suggested that the concept of wheeling be broadened a bit to facilitate the introduction of more renewable energy into the Jamaican system. The following is therefore being suggested. 1. Wheeling of power be permitted between pooled generation and consumers. And RE there is renewable energy. This would open the door to community solar installations, for example. Community solar enables multiple consumers to pool their resources and enjoy the economies of scale traditionally available only to larger installations. In the case of a community solar project, for example, multiple consumers centralize their generation in a single grid-tied installation and then wheel that power to their meters. This gives them access to less expensive equipment, financing, and construction services, while offsetting a portion of their consumption. Related to this point, it seems equitable that the generator of intermittent renewable power is not forced to firm that power. The requirement to firm this power results in perverse economics rather, and will promote the future use of on-site thermal generation as opposed to transitioning Jamaica to more renewable power. Rather, the renewable energy generation might firm some or all of their energy needs via battery energy storage or similar technology. And the wheeling charges paid to the system operator might include some reasonable fee for firming or capacity equivalent as deemed appropriate by the competent regulatory body. Currently, the ministry has three, two mechanisms for renewable energy. That's net billing and wheeling. And it allows for commercial and individual household participation. So for example, wheeling, it has a capacity for commercial use as well as residential use, net billing rather. In relation to wheeling, it is important to note that based on the provisions in the Act, there has to be a market study which determines that the self-generator requires additional capacity. And where that is confirmed from the market study undertaken by the OUR, then the self-generator will be permitted to wheel to another entity in which that self-generator owns more than 50% interest. So the shared construct that is recommended over there may only be done in relation to wheeling, as they have indicated.
Did we lose Ms. Campbell?
I'm sorry, I had to get
We
a
weren't
quiet.
hearing him.
Okay. So in relation to wheeling, as they have indicated here, in relation to the community concept, wheeling as the policy and the law permits can only be done where a self-generator has a license to generate its own electricity, and it may provide where that self-generator needs additional energy capacity, and the market study of the OUR confirms this. That self-generator may wheel from its location to one or more of its location elsewhere, and the self-generator must have a 50% interest in the entity that he or she intends to wheel this power to. And the policy and the law is limited in that regard. And therefore, we do not accept the recommendation from WRB Energy. I will also say that the draft wheeling regulations currently permits the use of renewable energy generation. Well, it's not yet promulgated, but it's in the making. And the provision will allow for that.
Why am I hearing a bit of a contradiction? So the policy as it is now under the Electricity Act is what it is. It requires market study to indicate need, a wheeler owning about 50% interest. But you're saying that there are regulations which are going to be more consistent with the recommendation WRB Energy is proposing?
No, the wheeling will be consistent with the provision in there. So
I see. Okay.
Yes.
I see. Okay. Members?
I can live with the recommendation, Chair.
I do too. Not, I do too. Members, other members. All right, Ms. Campbell, I think you have non-objection to the position of the ministry on that.
Thank you. The JPS is recommending in relation to addressing electricity theft and technical losses, a ban on incandescent bulbs. These cheap light sources are preferred by those who steal with no incentive to conserve. General purpose incandescent lighting is a wasteful, outdated technology that has been banned for environmental and energy efficiency reasons by the vast majority of countries globally. Implementing similar restrictions locally would reduce the quantum of energy stolen, and even without a reduction in the number of persons stealing. Now, the banning on incandescent light bulb for purposes have been identified by the ministry as one of the measures to be taken in order to achieve energy efficiency, and that is a key objective under the Electricity Act. The ban will be implemented in different phases from this year to 2027, and we'll begin with incandescent bulbs that emit less than 25 lumens per watt up to less than 75 lumens per watt. So it will be graduated over time up to 2027.
Is this ban that the ministry is intending to implement is part of which policy?
The the electricity, energy efficiency, achieving and promoting energy efficiency.
Okay. There's a specific policy document on that in the ministry?
I would take support from the technical team, but this is one of the key requirements of the Electricity Act.
So,
Hi,
Ms.
Brian.
Campbell, and hi, how are you?
I'm good, thanks. Go ahead.
Afternoon.
Let's hope you jump in.
So with regards to incandescent light bulbs, being part of CARICOM, Jamaica had signed on to having incandescent light bulbs taken out of the Caribbean region. I think back in about 2013 or 2014, I don't remember the exact date. And every island is required to implement incandescent. Several islands have, Jamaica hadn't, and it was the ministry's fervent wish to have this implemented under Minister Vaz, and it was done. It was started in April, and we will have a tiered approach to increase the efficiency of those bulbs over a period of time in line with what the technical improvements are. I just want to be clear that the 2027, after 2027, it's not that incandescents can come back onto the grid. They've been banned completely starting from 2023, April 1, 2023, because they're an inefficient way of producing light using electricity.
Okay. Okay, thank you. Just curiously, why the phased approach?
The phased approach is in line with CARICOM's policy that the government has adopted. So that's why. That's where
I'm sorry, you cut out. Say that again for me, please.
So the phased approach is in line with CARICOM's phased approach. This is directly from CARICOM's document in terms of the wording, not just the years, but the wording. And so we have put that in our policy position, and the year is there as well in terms of how we're going to achieve it. And so why you're going to have that phase is because as the technology improves, how much light you can get from 1 kilowatt hour of electricity is going to improve, and they expect it to improve to a particular number by a number of years. And we think by 2027 we'll be at that that number, that you get 75 bits of light coming from your light used.
I don't know if it's me, but you're cut out a little bit at the end there. But I think we take a point that by 2027, then we should have
more efficient
efficiency from our lighting sources. Yes, okay. Right. Okay, committee members, any comments on that? I certainly welcome this approach. Thank you, Minister Vaz and the team, for getting done what hasn't been done before. This is as welcome to me as Minister Samuda's ban on plastic bags. Ms. Campbell, I think you can move to the next matter.
JPS is saying, in relation to house wiring and certification, the cost of proper electrical installation and certification is a barrier to legitimate grid access. This requires the government to give priority attention to two related issues. One, the provision of assistance to defray the direct installation cost for house wiring to allow for the safe connection to the network. Surveys have indicated that this is a primary obstacle to application for electricity service. This assistance should be included in social safety net for basic utility service for vulnerable groups. We confirm, as has been expressed here, that the house wiring assistance is being given by the government through the Social Investment Fund, and these are costs in the project. The second issue relatively high cost and long wait time for certification due to inadequate numbers of inspectors frustrate customers' efforts to get grid connected and therefore contributes to theft. JPS recommends a revision and standardization of cost and acceleration in getting the government electrical regulator, maybe that should be in operation to allow more licensed electricians to perform the certification. This will clear the current backlog and facilitate the timely processing of future applications. Well, the government electrical regulator, their services, well, their setup was launched in 2021, I believe, and the government is no longer responsible for providing those services. So JPS's concern here has been addressed.
Yes, I do recall the bill that came through Parliament. Senator Allen, you recall when it came to Senate? There was a bill on this, wasn't there, Ms. Campbell?
There was a regulations.
Regulations, yes, yes. Okay, and we did in fact put into effect what they're exactly what they're asking for.
Yes, so now customers will have the choice to engage an electrical inspector of their choice, and it's now privatized, so they have access to.
I recall, yes, Senator Golden Campbell.
Okay, all right, thank you, Ms. Campbell. OUR.
The OUR is recommending that the regulator's powers and functions in relation to the electricity sector be included in the Electricity Act. At the very least, a general rate setting power for the electricity sector could be included in the Act, as well as specific reference to the powers of the OUR in this regard that are now set out in the OUR. For example, the Electricity Act could explicitly cross-reference the OUR's ability to exercise the powers under Section 4, 8, 9, and 10 of the OUR Act. That is the power to set rates in the sector, to issue directives and memoranda that require information, and to conduct investigations, etc. The ministry has no objections to the roles and function of the OUR being properly set out in the Electricity Act, so that those in the electricity sector would have the express reference and have this one document to guide them in relation to the powers and functions. So all parties involved would be certain and not have to go specifically to the OUR. So this is what OUR in fact does.
Right, but isn't that set out in the regulations that govern the OUR?
They're in the OUR Act.
Is it a statute or regulations?
It's a statute.
Okay. So these functions are set out in the OUR Act.
The functions are set out in the OUR Act, and but they are not, well, it governs all the prescribed utilities, which OUR is responsible for, and they may not be specifically detailed, but at sections 4, 8, 9, and 10 as the general functions. And we have no objections to amplifying the
What did you say about 4, 8, 9, and 10? What are you looking at?
Oh, the OUR's comment in the first column.
Oh, okay.
So we have no objection to make it clear what OUR's role is in relation to the electricity sector.
So you're going to have the role of the OUR set out in the OUR Act, and then you're going to repeat the role of the OUR under the Electricity Act. I'm trying to wrap my head around that.
So the role would be specific to the function of the OUR.
The functions of the OUR.
In relation to electricity.
Okay.
Yes.
But not conflicting with what is in the Act. Miss Eaton, are you there?
Conflict with what is in the OUR.
Hello, good
Hi,
afternoon.
Hi, Miss Eaton. You want to opine on that?
Well, typically, I mean, I would have to remind myself of the provisions of the OUR Act, but typically where something has already been prescribed, there's generally no need to repeat it, but there might be some nuances. So we would have to really look at the text, go through the text of the OUR Act, the specific provisions, and then to what extent the language is limiting or doesn't appear to extend to the electricity sector, and what would necessitate and to what extent those provisions should be reproduced in the Electricity Act.
I'm not understanding their concern to be that they don't think it extends to the electricity sector. I'm understanding their concern to be that while it extends to the electricity sector and other sectors, they want it repeated in the Electricity Act for the convenience of the electricity sector. Ms. Campbell, would you disagree with my interpretation?
Yes, in a sense, Chair.
Please clarify where I've gotten it wrong. Thank you.
So even though the OUR Act may set out some powers in relation to prescribed utilities, I hear what Ms. Eaton has indicated. In the Electricity Act, it's not merely repeating what is there. It will have the specific focus of this sector, of the electricity sector.
So you would then be including in the Electricity Acts things not set out in the OUR Act?
Yes. That would be so.
How would that work though? I'm confused.
If I may assist, Chair, since the recommendation came from the
Oh yes, Ms. Lewis, thank you.
Well, our recommendation is based on one, as you correctly indicated, the convenience for the electricity sector, because oftentimes we find in our interaction with investors and other interested parties that we have to be pointing them to the various pieces of legislation in order to find the complete powers of the OUR. And so it would be convenient to have it in one single place, a sector-specific legislation similar to that of the Telecommunications Act. Secondly, some of the functions which we include here, they are not stated in the OUR Act in explicit terms, because the OUR Act was promulgated in 1995. So this presents an opportunity for the OUR to include a more comprehensive approach of its powers that we exercise explicitly and by implication. So it would provide an opportunity to put all of that together. So in both senses, they will have a complete sector-specific legislation.
Okay. Members, you've heard the OUR's comments on that.
I mean, if the OUR is recommending to do it that way for its own to make things more efficient, the part that got me was when you asked whether things could be in there that are not in the OUR legislation. So that's the part that I was a little not thrown or concerned, but curious about.
And if I may just specifically address that point, yes, it is possible, because The OUR Act is a constituent act for the body itself. But in respect of the electricity sector, there may be particular things in the electricity sector that want the OUR to assume that responsibility. And so it can be empowering because, and under law, once you have a sector-specific legislation, it takes precedent over general provisions of an act. So it would override it in interpretation. So if we want the OUR to take on additional powers that are not in the OUR Act, then it can, the legislation can so provide. And in its interpretation, it would override anything that is generally set out in the OUR Act.
Okay, thank you.
Okay, and the ministry is supports the OUR's recommendation.
Yes.
Okay. Committee members, the ministry accepting any objections?
I have no objection. I found it a little curious that there was the OUR Act, and then we were going to put in additional provisions here in relation to the OUR and its responsibilities. But I hear the explanation from the OUR, and I'm going to assume that the ministry has gone through the list and it is consistent with what their view is of the role of the OUR. And since they've said yes to that, I am okay with it.
Okay, thank you, Senator Morris. Yes, so the chambers, Mrs. Mesada has just opined in the chat. I think she shared your concerns, Senator Morris. The committee members are supporting then. Ms. Campbell? Members, I'm looking at the time and I have to tell you that I have a conflict in a few minutes. So I'm going to ask if the committee members are not objecting, if we can take our last recommendation. I think we have managed to get through about half of the matrix, this additional comments matrix today. In addition to the preliminary matters that we dealt with. So I think we've made some good progress. So after this, can we move to wrapping up if there's no objection to that? Okay, Ms. Campbell, can you take us through our last one for this afternoon?
The OUR is also recommending that the Act contains provision for consumer protection and service quality. They have said it is critical that the Act be comprehensive in all matters pertaining to the electricity sector, including provisions dealing with consumer protection. It is recommended that provisions like Section 39 of the UK Electricity Act of 1989 and Section 63 of the Telecommunications Act be adopted. Suggested language for consideration have been itemized 1, 2, 3, 4, and 5. We recognize that the issue of consumer protection in respect of the electricity service is not properly consolidated or defined anywhere, and we have no objections because we have seen instances where there is need for the provisions and for an entity to assume the functions, and the OUR is rightly placed being the regulator. I know that
doesn't the OUR already assume these functions?
Yes, the OUR assumes these functions, but I think they are in the license.
Miss Lewis, are you there?
Yes, if you could share.
Yes, I'm here, Chair. Just I'm trying
I
to.
was forgetting that you were here before, you know, that's why I wasn't calling you first, but you haven't properly reminded me. Thank
Chair.
you.
Thanks, Chair. No, the OUR Act does not specifically have consumer protection provisions, and this is why we want them to be explicit in the Act. And oftentimes when we try to give even cases like equipment damage and for the payment of compensation, we can only make a recommendation to, for example, JPS, that compensation be paid, and there is no mandatory aspect of it for them to follow that recommendation. So in light of now, this is a good opportunity for us to really make it explicit. Currently in the OUR Act, the only provision dealing with consumers directly is that the OUR can evaluate the customer's needs and to ensure that the licensee is making that sort of provision for the licensee's needs, for the consumer needs. There is no provision in the current Electricity Act dealing with consumer protection matters. And this is very unlike the typical.
Say that again. Say that last part again. There's no what?
There's no extensive consumer protection provisions in the Electricity Act currently. And this is unlike other jurisdictions that deals with consumer protection issues, and even our local legislation dealing with telecommunications. It does have some explicit provisions. And so we thought that it would be best to have those provisions explicitly stated, that all can know the remit of the OUR's powers and functions and how it ought to operate. It gives also a level of transparency to our operation when dealing with consumer protection issues.
May I ask a question, please, Chair?
Yes, Minister, go ahead.
I had a question about what you just said, and maybe you can help me to understand. So currently, I assume that OUR has a consumer protection mandate, but you're saying that what is in the OUR's legislation is very high level, and that in the Electricity Act, there is nothing. But you also said that sometimes there is an issue in terms of enforcement, and you can only make recommendations vis-a-vis issues in relation to consumer protection. So the work that you currently do in consumer protection, where do you get those powers from currently?
We get those powers from our general or broad functions. So for example, it says, the office, where it considers necessary, give directions to licensee or specified organization with a view to ensuring that the needs of consumers are being met. So that is expanded to include consumer protection issues. And that is the extent to which we have those powers. So when we were reviewing the legislation, we went and looked at best practices internationally as to how it is dealt with, and we came across the UK legislation, which makes extensive provision for the consumer, and as such we thought that it would be best to adopt it, because as I said, not only will it give the teeth that we need, but as well as it sets out the framework and it brings to it a level of transparency, which we can adopt in our jurisdiction.
Thank you, Chair.
Is that's, if you're okay with that response, Minister Morris?
I am. I just, I think it's important. The consumer protection element is really, really critical. And so it's interesting to hear the OUR's discussion around some of the kind of impediments to them actually performing that role. and the need for this. So that was helpful for me in contextualizing the recommendation.
Well, let me just ask Ms. Lewis this, or maybe Ms. Lewis or anybody at the chambers. Is there the Consumer Protection Act itself does not, is it that the electricity sector is exempt from the Consumer Protection Act? Is not the service or the supply of electricity considered a service under the Consumer Protection Act, which itself provides some protection and powers to protect customers?
Yes, but those powers are not exercisable in its full remit by the OUR. What we do here in terms of the consumer protection that we are dealing with is not in terms of goods and services in the classic sense of buying a fridge or a TV. It's really in the provision of services which we have the expertise and which we act in, and to mandate certain standards for the JPS or any other utility. So that's the modus. So although the general consumer protection issues that speak to advertisements, you buy the goods and it should be able to use it, fit for use, that sort of thing. We find that in our sphere, we think it is better if we have specific provisions dealing with electricity services.
I hear you, and I'm certainly sympathetic to what you're saying. I think I'm a little concerned about how we construct our laws to basically vest essentially what is contained in one act in another act. I'm just a little concerned about that.
Chair, without interrupting, if you look at the provisions which we are proposing, for example, the prescription of standards of performance in connection with the supply of electricity services, and then publish those standards, prescribe standards of performance, prescribe a scheme of compensation to be applied where there are breaches of those standards, prescribe the circumstances in which a supply may make different provisions for different supply licenses or services. And then we go on to look at where any customer is affected by a failure to meet a prescribed standard, then they shall be entitled to compensation. So we are making it mandatory, where we have assessed that compensation ought to be paid, and that we have the enforcement power that when we make those determinations, that they can be enforced against the utility company. And we may carry out those investigations. So it brings a level of transparency as
who is going to carry out the investigations? OUR?
OUR, the OUR.
You're not currently engaged in that kind of activity, no?
We do carry out investigations, but as I indicate, in those circumstances, we are not empowered to issue a directive.
Just a
this is
recommendation.
What we are recommending, that it becomes enforceable in that fashion, and make it explicit, because if we should do it by implication, no, it would be challenged, I am sure, by the utility company.
Okay. All right, any others on this point? I'm on the fence on this one. I personally would appreciate a little bit more time to read a bit more on this. I mean, I have some concerns. I mean, as a customer myself who I have lost expensive equipment from power surges and that kind of thing. I'm trying to wear the hat of the utility provider. And as OUR has indicated, they do carry out investigations. But how do you determine that my very expensive coffee machine died because of JPS's poor service performance as opposed to something else? How do you really determine that? Ms. Lewis?
There are instances, so for example, usually with equipment damage, we would normally indicate to the customer that given the complexities of those matter and what the level of evidence that is required, that it would be best if they pursue that sort of claim in a court of law. Or in some instances where that has occurred, we would first sometimes even request the information from the JPS to say whether they had a fluctuation in their electricity supply to the extent that it may affect person's equipment, and depending on that data which we get, then we can naturally make that sort of analysis. And I see my colleague, Mr. Johnson.
And come up with a recommendation.
Yes, yes, and come up with a recommendation. But I will yield to Mr. Johnson.
It sounds a little imprecise to me, and a lot challengeable to me. Go ahead, Mr. Johnson. Good afternoon.
Yes, good afternoon, everyone. Peter Johnson from the OUR, and you asked a very good question. And it is, as you said, somewhat difficult to pin down. Usually, one of the biggest challenges is that the JPS system is what we call an open system. For the most part, the lines are accessible and are in public view and public access by accident or by intention. There are some things, however, that can be determined, as my colleague Ms. Lewis suggested, that there could be records of work being carried out, and then there could be investigations into how that work was carried out and whether or not there were any procedures that may have gone awry that serve to ensure that disruptions are not affected onto the system. There are, however, as you rightly mentioned, lots of opportunity for things to go wrong. And a typical challenge many of us have in Jamaica is the specifications of the equipment we have, which do provide a big out for JPS in that our equipment are supposed to be 50 hertz, and many of us have equipment that has a nice stamp on it that says 60 hertz. And that does give a note because the contract says 50 hertz. And there is another issue that many of us are probably not even aware of, and that is the grounding facility on premises, both either your home or your business, needs to be in a good serviceable condition. Most of us have it probably buried under concrete somewhere and have no idea that it even exists. But it does need to be serviced and kept at a particular level of operationality, which you would have gotten some certificate when you got your house inspected or your premises inspected. So the thing is that as persons, we do need to make sure that our own grounding is in good condition, because if their investigations show that the grounding of the transformer that serves your establishment or your home is on the utility side is in bad condition, then that means that they are not providing as good a supply as they should based upon the tolerances that their contract says they should, and of course what the electricity code said they should. So they are,
these are some of the things that OUR should be telling us as a matter of routine, Mr. Johnson.
Yes. I agree with you, Senator.
Because
Gordon.
you just said to in the much of us don't know this. I've never heard of this. I was looking around me right now, wondering where this place that is under the concrete could be.
Yes, it's usually close to your meter, so there's a grounding wire that ensures that, of course, if there's any imbalance, that your protective equipment can work. It's really bad. If your grounding is bad, your protection devices will not necessarily
So I'm
work.
repeating what I said, that this ought to be part of a public education campaign, and I'm sure there are other things that OUR should be telling us. But that is one scenario. You know, I am not naive, and I love my Jamaican people, but we're ingenious when we're ready. And I can see the potential for an issue causing damage to my beautiful coffee machine. It still hurts to this day. It was 15 years ago, JPS. Anyway, I can see my coffee machine being destroyed by JPS's power fluctuation. Let us assume I have no liability. I have done what I'm supposed to do. And if in my neighborhood, I'm close enough to people who know that, then everybody's machine and stereo equipment and television is suddenly going to have a problem and need replacement and compensation. How do we protect? How do you balance the interests when you have that kind of potential? Because what OUR is asking for here is a provision that mandates compensation.
Right.
And,
so okay.
All right. Well, I'm asking because as a legislator, I have a duty to look at it from the citizen's perspective, but I also have a duty to look at it from JPS's perspective, because both of them are citizens of the country, right?
Yes.
So how do we balance that?
So indeed, and this is where the investigation aspect comes in, because indeed there are several things that would need to be looked at. As you said, if you are making a claim of damage, then of course you would need to be able to demonstrate that damage that you say has occurred was due to fluctuation, and that level of fluctuation, if you're not the only person being supplied, would certainly tend to have some evidence apart from just your particular set of equipment that may have been damaged. So it really lies in the quality of the investigation that can be carried out to make some determination as to what were the probable causes of such incident. And I think the thing about it that makes it really clear is that if you do find the probable cause, it's usually pretty distinct, definable. There are things that, due to the nature of electricity, is very apparent in terms of the condition of equipment, what may have occurred, and these things only need a very small time to happen. But of course, the evidence can be there in terms of the condition of equipment, both on JPS's side and in terms of all the connections from a possible point of incident to the various places of use. So it all goes down to the quality of the investigation, and also had any repairs or anything been done, the persons who would have carried out those repairs would also be able to add their testimony to what they found happened to the equipment, and that would also lend support to their argument. So it comes down to the investigation, but the reality is that electricity is very powerful and can create a lot of damage, and when it does, it's usually significant. So this is something that you want to make sure that the utility is doing all it can, both in terms of how it sets up and operates its facilities, but also in terms of the persons and the crews who work on the system, whether in design, construction, or maintenance, or responding to an issue, that they also work safely, not only for their sake, but also for the sake of the grid and the customers connected accordingly. So it's a real and expensive problem when it occurs. And we want to make sure that where it's clear that there is an issue on the utility side, that we can put things in place to ensure that we are careful to put in policies and procedures to ensure it doesn't recur.
Mr. Johnson.
Yes.
What is the current administrative process and setup to deal with matters like this? Does OUR have a complaints division?
Well, Cheryl may want to take this, but while we don't have a complaints division, we have an appeals process, and the appeals process chips in if the customer is not satisfied with the with the results of their complaints with the utility. If they do bring an appeal to us, then yes, we do have a process for carrying out further investigations. Cheryl, would you want to add?
Yes.
And let me add to that, Ms. Lewis, before you answer. Because you referenced OUR's current engagement in investigations, and after which you make a recommendation. Tell me about that investigations team, and tell me, is that a division? Is that how many team members do you have that staff that division or that unit and carry out those functions?
Okay, currently the OUR has a department known as the Consumer and Public Affairs Department. In that department, there are two main units. There are others, but two main units dealing with customers, which is the public affairs and the information side, and then we have the consumer affairs unit. So those publications that you see where the guaranteed standards, where we assist in collecting monies for customer on a quarterly basis, we publish those and report. So that entity is responsible for dealing with the consumer issues. However, in terms of investigation, that unit partners with the RPME department, which is a regulation and policy monitoring and enforcement department, to conduct investigations dealing with consumer issues. We also have a provision where for certain matters we might not have the time to deal with it, so we procure consultant expertise, engineering services to assist us in investigating those claims when they do come in. The ordinary claim that comes in, we have customers service officers. There are about, I'd say a team of about 8 persons dealing with customers. We are ISO certified in that our processes are standardized, both in terms of our appeals process, and our preference really was to deal with the appeals process because when customers come in and have a complaint, we would have to go to the utility company and for them to send us the information. So the preference was to have the utility company and the customer deal with the complaints, and if a customer is dissatisfied or aggrieved with that decision, then they come to us as in an appeals process. However, over a period of time, we have noted that the appeals process have significantly declined. And so what we have instituted now is a robust complaints process where we assist the customers who come to us, and we try to resolve those issues, and the procedures are well laid out. So we do have that processes and a unit that actually deals with it. As to whether we are adequately resourced, that is a challenge which the Director General has always spoken about, the resources of the OUR. because of the nature of what we do and the multi-sector approach. We are just not getting complaints simply from the electricity aspect, but we are also getting complaints from the water and sewage services and also from the telecommunication services. So we are a big challenge, but in the circumstances, I think the team has done excellently in coping and
so you want to give them more responsibility so that they have to try harder to cope.
They already have the responsibility.
You really want to challenge your team and test their mettle.
No, not from that perspective, but remember the OUR is here to serve and to ensure that these critical services, which are evident for national growth, is carried out in such a way and the customers can in fact utilize these services efficiently. And so that is what we are here for. And
I agree that's what you're here for, but you're asking us to put a scheme in place in the Act, which is not simply inserting provisions that set out OUR's role. It has bigger implications. So when you talk about setting out that, you know, there's a customer affected, I can't read the screen so well on the Zoom. Let me go back to my Word document. That a customer affected is entitled to compensation. That word entitled alone creates a mandatory process and scheme that has to be managed and administered by somebody who would be the OUR. That's one part of it. The some of the others that you set out here are other parts, you know, also create what I think is, not that you're not engaged in some of this, no, but I think it certainly expands your obligations, your performance obligations. And I'm not saying that's a bad thing, but my question would be, how are you gonna do it? How are you gonna get it done? Is the Jamaican citizen really going to be served by dealing with it in this way, i.e. putting these roles and responsibilities under the Electricity Act? I have questions about that. I'm also very interested in hearing, you have 8 investigators, you say 8 customer, what was it? 8 customer.
Right, about 8 customer service officers. There are other persons dealing with.
How many people work at the OUR in total?
We have a complement of over 70. 70
people. The regulator has 70 people from the CEO down to the office assistant.
And we have made an application to the Ministry of Finance to reorganize our organization structure to incorporate, because based over the years, we
and to expand it to what, Miss Lewis?
I can't recall
from 70 to double it?
No, not double. Not double.
Okay.
But
so you want to move from 70 to something less than double. Less than double is 140, right?
No, that's
less
than
140.
That's way above what I think we had proposed. To be honest, I can't remember the exact figure.
So what I'm getting at, you know, I would want for this to be fleshed out a little bit more. I'm suggesting to my committee members that we put this one in the parking lot to revisit on the next occasion. I don't think it is as simple as making it explicit in the Electricity Act. It has some other very serious implications that I'm not clear, and I'm not sure at this point, even based on what the OUR is saying, that the OUR is in a position to deliver it if we are to make it a statutory mandate. Not certainly without some changes in how you operate and how you're tooled. So that's a policy matter, yeah?
But
that has to be dealt with.
But for the most part, we undertake quite a bit of what we have here. This would be nothing new to us for the most part. as I said, we do it by implication in some of the cases, and where we are challenged, we have to take a step back because it is not explicitly stated. And so it would be best, as we have suggested, that it be explicitly stated. But I do appreciate your point that the committee members would want to have a relook and a retake on this before making a decision. But and also to recall, Chair, that we are making for legislation, not just for today and an existing entity. We're looking at legislation for the next 10 years, 20 years. And with the advent of AI and all of that, that may radically change how we do business. We have to really look at not just a static approach, but look at the customer base as we move forward, not just on the OUR's current status.
But I agree with you, and I thank you for that. But my problem is that I feel I'm in a cart before the horse situation, because what I would want to hear the OUR saying is that these are our plans in terms of how we're going to do business in the future. These are the areas that we are not adequately covering now because we don't have the legislative support for it, but we will be covering, and this is how we're going to do it. Not that we make law and then we figure out how to get to it.
No, Chair, by no means. And this is why I brought up the idea when you asked about how the OER is resourced, that we in fact had undertaken, with the approval of our board, a new organizational structure, because we recognize that the OUR needed to be right-sized in terms of the amount of work and all the dynamic changes which have been happening. And so with that, within that context of having the OUR working more efficiently, we undertook to examine the organization, to look at the organization and to see how best we can function and function efficiently. Having done so is simply one aspect. The second aspect is now, do we have the legislative powers to do some of what we are doing, and where we need to have it on a preference basis, to have it explicitly stated for transparency issues and for everybody to be aware that this is in fact the remit of the OUR, because the OUR also doesn't want to act illegally and step outside the boundaries of its powers, because as an agency, it is critical for us to stay within the boundary of our powers. And so this is why we have sought to adopt international best practices. If you look at every legislation throughout the Caribbean and throughout the developed country, there are provisions made for consumer protection. And even locally in our Telecommunications Act, there's a whole chapter of that legislation dealing with consumer protection issues. And I think that that is what we wanted to replicate in the Electricity Act, and to ensure that electricity customers have that same level of protection that is enjoyed by the telecommunications and by and whether locally or internationally in other jurisdictions. So that is where the OUR is coming from. Not simply to have powers simply just because. We see the need for it, and this is why we did our research, and we have indicated that.
No, I wasn't suggesting you wanted to have it just because, I just wanted some clarity in terms of how you propose to meet what would then become a statutory mandate and obligation for you. So thank you. I still want to mull on it. There's some things I want to read up on. So I would still like us to part this one. Are there any committee members who feel they're prepared to move forward or wish to give it some additional consideration? Senator Allen, are you trying to say something? Go ahead.
And I'm going along with you in terms of to revisit. Right?
Thank you. All right. Minister Morris, is she still here?
Yeah, I'm here. And
okay.
I hear your concerns, especially, it's one thing to put it in the act, and it's a different thing to actually have it come to life. and to actually be real for consumers. And I think the consumer protection element is an important element. And so the points you've raised are important, and I think it's worth us just giving it some thought, because this is an entirely new section that we'd be putting in. So I'm supportive of you, Chair.
Thank you. I know Member Jackson had an emergency that he had to attend to, so I don't think he's any longer with us. Okay, so that said, thank you very much, Mr. Johnson and Ms. Lewis from the OUR, and thank you, Ms. Campbell from the ministry. That said, we are at the hour of 4:45. I had indicated we would look at the September 13 minutes. I am going to use the privilege of my newfound power in the chair to defer those minutes to the next meeting when Minister Vaz will come back and what is the word? Yank the power away from me. So with that said, Ms. Campbell, please note where we have stopped. And I ask that we pick up when Mr. Vaz returns with that provision on the next occasion, and also the ones that the ministry wanted some additional time on. Please note those. Ms. Beckford, can you just make sure those action items are clearly marked in our minutes? Thank you very much. And with that said, can I get a motion to adjourn for today? Our next meeting, Ms. Beckford, is
October 26th at 2 p.m.
October 26th at 2 p.m. members. Might I have a motion for the adjournment of the committee?
I very much so move, Chair.
Thank you, Minister Morris.
Dana, seconded.
Seconded by Senator Allen. Thank you very much. Thank you to the team, to the chambers, OPC, OUR, and all the technical team. Thank you all very much. Have a good evening.
Here is a special parenting message brought to you by the National Family Planning Board, 5 Sylvan Avenue, Kingston 5. The way we treat our children directly impacts what they believe about themselves. That was a special parenting message brought to you by the National Family Planning Board, 5 Sylvan Avenue, Kingston 5.
Now this one, you have to say with a little cutter, you know. Hardiest picnic grave there roadside. In other words, misfortune will befall those, especially children, who don't listen to their parents' advice. That is why them say, hardiest picnic grave there a roadside.
Speeding kills. Obey the speed limit. A message from the Road Safety Unit in the Ministry of Transport and Mining.
Mommy?
Yes, Zoe?
Can we read this book? It will only take 10 minutes. Sure, sit down. Every spring, Madame Angel Wing arranges.
Do you have 10 minutes? Read with your child today. Reading with your children for just 10 minutes each day helps develop their language and listening skills, stimulates their imagination, and expands their understanding of the world. So, start reading with your child today.
A major area in high school for me was IT and EDPM. I did that for 2 years, and from then I realized that there was a drive for more of technology. So I decided to take this step.
The following is brought to you by the Office of the Prime Minister.
Your government is empowering you through education, training, and development. That is why we have removed all fees for every Jamaican accessing training through the Heart NSTA Trust. So, whatever you desire training in, food and hospitality, beauty and cosmetology, housekeeping and hotel management, welding, carpentry, masonry, or any of the dozens of programs Heart offers, you can enroll completely free and change your life. We are building Jamaica.
The proceeding was brought to you by the Office of the Prime Minister.
The only woman to stand proudly among 6 men as Jamaica's sole national heroine is Nanny of the Maroons, or Granny Nanny, or Queen Nanny, as she was and is still affectionately called. Much about the right excellent Nanny of the Maroons remains a mystery to this very day. Much of what is known about this Jamaican female rebel, who rose to be a domineering leader, driving fear into her subjects and enemies alike, was passed down through Jamaican folklore. Despite the contradicting versions about her past, she is forever credited as being the matriarch of Jamaica's Maroons and the architect of much of their strategies used in warfare against the British colonialists. Nanny's invaluable contribution to the fight for the freedom of her enslaved brothers and sisters was recognized officially in 1975 when she was conferred with the Order of National Hero of Jamaica. Queen Nanny is presumed to have been born in the 17th century in Africa's Gold Coast, now known as Ghana. A member of the Ashanti tribe, she brought their practices and beliefs to Jamaica, which characterized her stewardship of her maroon subjects. These practices also featured heavily in the battles waged against her British enemies. Nanny's leadership of the Maroons is said to have begun in the early 18th century. This after Nanny and her brothers Akompong, Kojo, Johnny, and Kwao ran away from their plantation owners. The siblings would form maroon factions across the island. Nanny and Kwao took to the east, Kojo to the west, leading a following called the Leeward Maroons, while Akompong set down roots in St. Elizabeth in the southwest. The Maroons would wage a brutal war against the British to maintain their autonomy. Their determination to be independent of the slave plantations would result in them becoming self-reliant and controlling much of the interior lands of Jamaica. They produced their own food from the land, which they in turn bartered in the towns for other items such as weapons and cloth. They would take their mission even further by raiding plantations for weapons and food and rescuing slaves who they would give safety in their villages. This would compound the Maroons' already combative relationship with the plantation owners and deepen the battle between the two sides for supremacy. Queen Nanny would be a force to reckon with on all fronts, but none more than as the strategist of battles fought and won by her Maroon soldiers. Nanny is said to have been a superb guerrilla warfare strategist. She would develop cunning camouflage